Good morning. This is Judge Alyssa Perez presiding over the 210 District Court Civil Docket for May 3rd, 2023. All matters being heard today are being heard in accordance with all emergency orders regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our first case, please?
Page 1, Judge. In cause number 2020 DCV 4192, Victor M. Reyes versus Leonia Cervantes and Gabriela Cervantes. Announcement of council, please.
Did I see Mr. Beal?
Good morning, Judge. Albert Beal for Mr. Reyes.
All right, Mr. Beal, where are we on this one?
The court ordered the property sold. I had to named a person to list it. I would like to amend our order to make that person designated the receiver, so she can. We left that out of the order, and it's caused us a little problem. So if we can get that, I think we can get the property sold.
Okay, if you will submit an amended order, I guess we want to call it an amended order.
Okay, yes, I will do that today, Judge.
And then I would like to set this for another status conference. How long down the road do you think we should set that?
6 weeks.
6 weeks? Okay, I'll put you down for 60 days on a reset, but please send me that order, okay?
Okay, I will.
Thank you, Mr. Beal.
And Judge, I have another case here today.
Correct. I think if Mr.
I saw Mr. Riojas here.
Mr. Riojas.
Good morning, Judge. I'm here.
Morning.
On page 2, Judge. In cause number 2020 DCV 2345, David Jones versus El Paso Cowboy Construction LLC et al. Announcement of council, please.
Robert Riojas for the plaintiff, David Jones.
Albert Beal here for Roberto Martinez.
Gentlemen, we're here for a docket call. Mr. Riojas, did you get any more information on your client?
I've been trying to, Judge. That's why somewhat hesitant to file that motion for continuance, although I did finally get it filed. But I'm still trying to speak to his public defender about the events of Monday's hearing. I understand there was some kind of plea deal offered or discussed, but beyond that, I haven't gotten any more information, unfortunately.
Okay, I don't see Miss Cables. Are you here? Yes, Miss Cables, do you see a motion for continuance? I don't see it on Odyssey, but honestly, the way yesterday ended, Odyssey had all kind of technical errors, so we weren't able to see much.
Judge, some of my filings have taken 4 days to be accepted or rejected.
Yeah, we're having some real issues here. I know yesterday we weren't just even able to visually see many things.
I can email it directly to your honor or to your staff, and along with the attached proposed order, if that is helpful to move.
Yes, Mr. Riojas, can you tell me what kind of timetable you're asking for? And then Mr. Beal, I need to know your position on that.
Judge, I would think something like 90 days out. I'm not sure how full your docket is. Maybe really up to the court's discretion, Judge. 6 months, if that's. I'm sure you. I'd like to get
probably more in the range where I can at least try to fit you in. But Mr. Beal?
Judge, I don't have a problem with the motion for continuance as long as it's on plaintiff and not defendant that we ask for the continuance.
All right. Then, Mr. Riojas, if you'll go ahead and send that to Ms. Myrna, to Mr. Hernandez. So if it's in the queue somewhere, at least we can get it signed. I'm going to grant the motion for continuance. I can't give you a definite trial date right now, but I'm going to look for the best date, probably in the 6-month range. Okay, just in case that that other case stalls a little bit, and we'll still leave you a little bit of room. Okay.
Understood.
And Judge, Mr. Rojas did send me a copy of his motion. So
great. Okay, so basically I just need the order, Mr. Riojas. Thank you very much. We'll get you all new dates. Okay.
On its way, Your Honor. Thank you.
Thank you.
Thank
Take
you,
care,
Judge.
guys. Take care. Who's next?
Back on page 1, Judge. In cause number 2021 DCV 3174, Luis Hierro Perez versus Durham Carriers et al. Announcement of council, please.
Good morning, Judge Ashley Seal on behalf of the plaintiff.
Is there anyone here on behalf? I see we've got a bunch of status conferences here. What's going on, Ms. Cedillo?
So, Your Honor, on the last one, we said that we were going to do a default judgment. We have the default judgment filed. We're pending for it to get accepted by the county court's office or the district clerk's office. And then in which case, however, we weren't unable to get a contact information. I'm having someone find an email address for the defendant that we're doing a default judgment against, because you did indicate that you would like them present for when we do a default hearing and at least have proof that we've served them additional notice of our default judgment hearing.
Okay. So if we're having all these issues in terms of being able to see filings, I'm just going to set you for a 30-day status. Once you have a file stamp copy, please email that to Ms. Hernandez so we can get you a hearing. You can anticipate it will be on that date. So 30 days out, okay?
Yes, Your Honor, thank you.
Thank you very much. Who's next?
Your Honor, I'm also here on another case, if that's okay.
Which one is it?
Bottom of page 4, Judge.
Okay.
In cause number 2021 DCV 4185, Randy Nakeda versus Lola Vanessa Rogers. Announcement of counsel, please.
Ashley Cedillo on behalf of the plaintiff.
Jose Vega here on behalf of the defendant, Judge.
Okay, we're here. Final civil pretrial. Did you all mediate?
Judge, we're in the process of setting that up. I had ordered some medical records on this one from Providence, and we just got them. We're producing those records, so we're going to mediate and hopefully try to save on the expense of depositions, and hopefully get this case resolved. If for some reason we don't settle and we get in a time crunch, Judge, I will file a motion for continuance. I apologize for the delay. It just took a little while more than expected in getting those medical records.
Okay, so we have our trial setting on the 16th, docket call on the 14th. If you all are able to schedule that mediation before the 14th, then I don't have a problem just reconvening on the 14th, see where you are, and if not, please have an idea of a turnaround time for a new trial date, okay?
It shouldn't be long, Judge. For some reason, I seem to be going trial to trial left and right. I think that all that COVID stuff is finally catching up. I went to trial last week.
I know that. Yeah.
I go to trial next week. Yeah.
You're preaching to the fire here.
So for some reason, this summer does look a little busy, which is good. I feel like an attorney again.
Yeah, it's been a year. So please, where are you in terms of scheduling that mediation? Does it look like who are you mediating with?
It looks like with Ancliffe. I think that's what we had agreed to.
Okay.
I think the only thing is that Ancliffe is extremely booked up, so we're trying to see if maybe he can fit us in earlier.
Yeah, but that's going to be the issue. We'll see you on the 14th, okay?
Yes,
okay, thank you, Judge.
Thank you. Take care. Who's next?
Bye-bye.
You may.
Top of page 3, Judge. In cause number 2022 DCV 3599, Myrna Yolanda Quiñones et al. Versus Greenwood Motor Lines Inc. et al. Announcement of counsel, please.
Good morning, Your Honor. Daniela Abinalti for the plaintiff.
Good morning, Your Honor. Amado Montoya on behalf of Alberto Hernandez Jr. and Greenwood Motor Lines Inc.
Okay, scheduling status conference. I guess we took an attempt at mediation, unsuccessful?
Yes, Judge.
Okay, so we're at a year out in term, and I'm going to say from today, in terms of a trial setting. Is that a problem for you all to go so far out?
No, Your Honor. My client is having surgery, so
okay.
Well, that will give us a chance for her to complete the surgery and go through the defendant, all the doctors, and
so let's do it. It's going to be May 3rd of 2024, the trial date. Exactly 1 year. For how that works out. Anyway.
Well, Carlos is always busy trying cases, so I'm sure I'm sure he will not mind. But go ahead, Judge. Yes, we'll go.
May 3rd, May 1st docket call. You all know the final civil pretrial is 30 days before the docket call mediation deadline. That we'll have another mediation deadline as the case proceeds, so you can take another stab at it. And so if you look at your schedule,
my client is having surgery, Judge, so I'm sure they wish they would have settled the case. But I am very thankful to them that the case did not settle. But hopefully, right now, with a new trial setting, we'll get going.
Okay, so we'll get you the scheduling order, return it. You don't have to come to that 3 p.m. setting in 2 weeks. And then we'll just get you all your regular settings. Anything you need outside of those settings, just request them. Thank you very much.
Thank you,
Judge, I have
Your
another case, but I will wait. I'm not gonna cut in front of anyone. So if I need to wait, you can just.
Which one is it?
Top of page 4, Judge.
Are we? Yeah, we're ready on that one. Let's go on that one.
In cause number 2023 DCV 0851, Jesus Quiñones versus International Eagle Enterprises, Inc. Announcement of council, please.
Good morning, Your Honor. Again, Daniela Labinotti for the plaintiff.
Good morning, Your Honor. Chantel Cruz for defendant.
Morning. So this was a recent transfer from CC6. I just have us for a status conference. It looks like it was recently filed. So are we ready to just get our scheduling order, trial date, all that kind of thing? Or do you all need to wait for a minute?
Chantel, what would you like?
If we need a date to work toward, that's fine with me. I mean,
All right,
we
let's do
just
that.
filed our answer, I think a couple of weeks ago, so we haven't even done disclosures or started on written discovery yet, so.
Correct.
So y'all want a trial date? If you do, then I'm gonna go with that May 3rd date as well. May 3rd,
Perfect.
2024.
Sounds good.
Ladies, we'll get you the scheduling order. Please return it. Thank you very much.
Thank
Thank
you.
you, Judge. Good to see everyone. Bye-bye.
Y'all too.
Bye.
Take-
Thank
Who's
you.
next?
Staying on page 4, Judge.
Mhm.
In cause number 2022 DCV 0662, Wilmington Savings Fund Society FSB versus Charlie Jones Jr. et al. Announcement of council, please.
Good morning, Your Honor. Travis Gray for the plaintiff. And Your Honor, I think Hector Beltran, the ad line might be on, but he emailed me just a minute ago and said he's also on Zoom in a case in California. So,
So he's double zooming.
yeah, but he actually just sent over to me the agreed motion for interlocutory judgment, calling for his attorney's fees and him to be discharged as the ad litem since he's completed his duties. You know, we've identified all the errors, named them in the amended petition. I've got one disclaimer that a non-suited get that interlocutory judgment to the unknown heirs, street statement of evidence, paid Mr. Beltran's ad litem fees amount of $3,000. We'll cut that check today. And then I have been in discussions with Mr. Enrique Silva, who, if you call, he's, I believe, the oldest son who's overseas. He's been working with Navy Federal Credit Union on getting a loan to pay off our loan, and I sent him on the 26th by email just a bunch of documents that they were needing for underwriting, like our title report and all that stuff. So, you know, it's like I said, this one's kind of awkward because I'm moving 2 different directions or trying to appease the court at the same time and my client, so I guess at this point we'll get discharge Mr. Beltran. Mr. Silva will keep working with, if he still wishes to purchase the property. My client's obviously willing to.
I'm sorry, sir. Can you start after we said Beltran, start with that one again. Mr. something.
And before we get started again, Mr. Gray, I see Mr. Silva is in the waiting room.
Oh, he is? Okay.
Right? Yeah. Is Juvencio Pacheco?
He's on another cause number.
All right, well, we needed Mr. Silva. So just offhand, let me ask Myrna, as we're waiting for Mr. Silva, it looks like he's logging in. Did we receive anything from Mr. Beltran? I didn't, in looking at. I
He
didn't-
sent, it's a joint motion for entry of interlocutory interim judgment to the unknown heirs that he's just sent back the signature to me this morning. We were just hashing out the ad litem fees and got that. So I'm going to submit to the court as soon as I was actually signing it right when Zoom came on. So I'll e-file it by noon.
Okay. All right, Mr. Silva, are you there?
Yes, Your Honor.
Okay, sorry, you were in the waiting room and when we called the case and Mr. Gray is here, he had an update for us. Mr. Beltran is in another hearing. And so, Mr. Gray, in terms of the documentation you received from Mr. Beltran, I know you're almost done finalizing that. We want to just do another status conference at this point, and if so, how far down the road do you?
60 days, if that would work.
Okay.
And Mr. Silva, is there any, I sent that title info. Is there anything else Navy Federal is needing from our end since we've got you on?
No, I'm actually, I gave him all the documents and the loan is it's being in process, so within the next 30, 45 days, I should hear something or sooner.
Awesome.
And if I do hear something, I'll shoot you an email, sir.
Yeah, well, definitely. Okay.
We are gonna reset this based on that timetable. It might be a little bit tight, but we're gonna, just to stay on top of things, set it for 60 days for a status. If you have anything in the interim for the court, please send it over. But we'll reconvene in 60 days on that.
Okay, thank you. Thank you. for
Mr.
that.
Silva, thank you for logging in today. All right, who's next?
Up on page 5, Judge. In cause number 2022 DCV 0998, Eduardo Canales versus Isaac Arroyos et al. Announcement of council, please.
Morning, Your Honor. John Alfiero on behalf of the plaintiff.
John Dickey for defendant, Isaac Arroyos, Francisco Arroyos, and Ruth Arroyos.
All right, bear with me 1 second.
And Judge, Mr. Alfaro may correct me, but I thought there was another Cisco Holmes that entered an appearance too. Am I?
She did. What was her name? Elia Garcia.
Where is Miss Garcia? Mr. Marufo.
Was on, I think she logged out, Judge. I'll call her office again.
Okay, well, we'll come back to this one. What happened to the rest of the 10 o'clocks? I see Mr. Aguilar. Is Mr. Morazzo not here?
No, I just placed a call to his office, Judge. No answer from them.
Mr. Copeland?
I haven't reached out to Mr. Copeland yet, Judge.
Okay. All right, let's go to the next one, please.
Staying on page 5, Judge, in cause number 2022 DCV 2618, Danielle Pons versus Landstar Hotels LLC et al. Announcement of council, please.
Good morning, Your Honor. Manny Morg on behalf of Ms. Pons.
Jonathan Davenport on behalf of Landstar.
Gabriel Canto on behalf of Aluminum and Window Solutions.
Okay, is that everybody? All right,
Yes.
scheduling status conference. You're all looking for a year turnaround on this one?
Or a bit more. We just answered 2 weeks ago.
Hmm.
So
Wait a minute.
towards the end of 2024 would be our preference.
Okay, well, we usually do a year. Is this, especially complicated or?
No,
Yeah.
that's okay. That's okay. I won't fight you on it.
So we're gonna do May 3rd, 2024. Get you the scheduling order, return it. Have you all discussed a mediator?
We have not, Your Honor.
Okay,
No.
please include when you return the scheduling order and agree to mediator, and we'll get you your settings, okay?
Thank you, Your Honor.
Thank you
Your
very
Honor.
much. Y'all take care.
Will be excused.
You may.
Thank you.
Who's next?
Bottom of page 5, Judge, I believe we have everybody in cause number 2019 DCV 0505 Hotel Sancho Panza LLC versus FT James Construction Inc. et al. Announcement of council, please.
Sylvan Lang and Megan Gillette on behalf of the plaintiff, Hotel Sancho Panza.
Stephen Nicky on behalf of FT James Construction, Inc.
And Robert Skipworth, Your Honor, on behalf of Magic Stone.
Good morning, Your
I'm
Honor.
John Dickey. I'm here for Harold Davis on behalf of Jordan, defendant.
Okay, third time's the charm. Michael Hirsch on behalf of Rooftoppers.
Catherine Stark on behalf of Otis Elevators.
Marwan Bhatti on behalf of Bass Celtic Inc.
Last call, is that everybody? All right, good morning, everyone. I feel like we were just here on this case and I'm looking at Odyssey. I think it says March. That seems kind of soon. Were we supposed to come back much later? I'm a little confused. Or did we get everything all wrapped up that quickly, Mr. Lake?
No, we've made a lot of progress. Otis and the hotel are about resolved. We've just got to finish some paperwork. We have settlement agreements pending with Glass House Daniels Rooftoppers as well. I think Mr. Nicky, on behalf of the general contractor, needs to put some final blessing on those to get them taken care of. Then that's really only going to leave Bowmanite, Magic Stone, CF Jordan, and the general contractor. I'd like us to have at least another month to try to work out these final details amongst ourselves without having to go to a mediation. I don't think we need the expense of a mediation. Mr. Nicky, what do you think? Agree or?
No, that's fine with me. I have no problem with that.
Yeah, I'd like to say we can get it done in the next 30 days, but that may be a little ambitious. If you could call us back in 60, and if we can't get it done by then, order us for a half-day Zoom mediation. But I think we ought to be able to get it done. We're fairly close.
Anyone else have some input on that? A 60-day reset. I mean, I don't have a problem with 60 days, but I think after that, we need to get something more concrete in terms
This
of.
is John Dickey. We have no problem with 60 days.
I'm fine with 60 days.
Okay.
That's fine.
Okay, thank you, Mr. Skipworth. Okay, then we are going to do that scheduling status conference for 60 days. We'll see you all then. Thank you for your efforts.
Thank you, Judge.
Thank you, Your Honor.
Marwan, I'll call you a bit later today.
Thank you.
You all may be excused. Thank you very much. Who's next? So I see Mr. Marazzo and Mr. Aguilar, so I'm just going to call it. Let's see, city calling cause number 2021 DCV 4284 CityLink Trucking Inc. versus Dump Bodies et al. May I have announcements, please?
David Mirazo for the plaintiff, Your Honor. I apologize. I had this as a final status conference. I thought it was canceled due to the moving of the trial setting, but I'm sorry. I'm here.
Okay.
Tony Aguilar on behalf of Dump Bodies Inc. and Hugo Aaron Hernandez Vega.
Okay, and yes, we are set. I think we still have the final status set and we don't have a trial setting. Can I get an update from you all? Has anything changed?
Your Honor, we're still trying to get service on two additional defendants. We served one out of the three additional ones. It looks like we're going to be filing a motion for substituted service soon. And also, I think Mr. Aguilar just filed something bringing in two additional third parties. So I guess the case is growing and we will address those accordingly.
Also, Your Honor, also we have the writ of mandamus pending in the 8th Court of Appeals. Mr. Marazzo has till May 25th to file a response, so that's pending.
That's correct as well.
Oh, shoot. Are you all, what are your all's thoughts on getting a trial setting in 2024 at this point?
My view is that it's always helpful to get one and have one in place. Obviously, when additional defendants come in, a lot of times they ask for something different. So,
okay, here's Mr. Aguilar. Any thoughts on that?
No, ma'am. It's just that Mr. Marazzo brought in other people, and that forced me to bring in people, and of course that delays everything. He's not served the two other defendants. I brought in two third parties. They've not been served yet. So a trial date, I guess you're saying everything May of 24. That should give us.
Yeah, but your all's is probably a little different, especially with all the kind of different things that are involved here. Not because I want to delay it, but just to be, I guess, practical. Rather than set the trial date now, what I'm going to do is set this for a scheduling status conference in 45 days. Okay, we'll do 45 days. I was gonna go to 60, but God, that just kind of, I don't know, maybe it doesn't bother me that much, but we'll see where we are in 45 days scheduling status conference. That still doesn't put us too far back in 2024. I feel like we're gonna end up at the end of 2024, but we won't know that yet. Okay, and see if we have any more things resolved at that point.
Fine, ma'am.
All right,
Thank you.
thank you, gentlemen. Have a good day.
Thank you, Your Honor.
Who's next?
Bottom of page 6, Judge. In cause number 2022 DCB 3622, Mary Gonzalez versus Jovencio Pacheco and Rebecca Pacheco. Announcement of council, please.
Good morning, Your Honor. Naseem Saloom on behalf of the plaintiff, Mary Gonzalez.
Enrique Lopez on behalf of the defendants and the movements in these two motions, yeah.
Bear with me 1 second. Okay, we're set for a temporary injunction hearing and a motion to compel. Mr. Solo?
That's correct, Judge. But both motions were filed by Mr. Lopez.
Yeah, I cannot open. Oh, this is not something that I printed out. Give me 1 second. Mr. Lopez, you can proceed. What I'm going to try and do is log out of Odyssey and log back in and see if that makes my access any better.
Very well, Your Honor. Enrique Lopez on behalf of the plaintiffs, Pacheco. My clients are the owners of a certain real estate property located in El Paso County, Texas. At one point, my clients, the owners of the property.
I'm sorry, do we want Mr. Jovencio Pacheco to be connected for this hearing? Because he's connecting to audio, ma'am.
Okay. It's not necessary. I think this is for we gave him the Zoom link just in case. I don't think there's going to be any evidentiary presentation. It's more arguments of counsel.
Okay, go ahead, Mr. Lopez.
Thank you, Your Honor. As I was telling the court, my clients are the owners of a building, commercial building, located at 8104 North Desert Boulevard. It's on the Upper Valley in El Paso County, Texas. My clients had entered into a landlord tenant with an option to purchase with the plaintiff, Mary Gonzalez, on basically a lease agreement with an option to purchase that was done in January of 2022. That contract expired after 2 years. The defendants, the plaintiff, Mary Gonzalez, never purchased the property. Subsequent to that, there was an attempt by Ms. Gonzalez to try to purchase this property again. They purportedly entered into a real estate contract. Unfortunately, the plaintiff never followed through with the proper formalizing of the contract, specifically making the cash deposit into the escrow account. And as such, it is the defendant's position that contract was never effectuated. My clients then, since they were still tenants, tried to do a forcible detainer, an eviction on the plaintiff who has been renting this property. Subsequent to that, or prior to that, plaintiff Mary Gonzalez files this action claiming that she's trying to purchase this property. So therefore the eviction and rightfully so stopped, and here we are. The reason that I filed this motion for temporary injunctions and to require the rental payments to be deposited into the registry of the court. As I indicated, they've been leasing these properties since January of 2020. After they filed the lawsuit, and since April of last year, plaintiff Mary Gonzalez has failed to pay the rental. In other words, she's just occupying the property without without making any payments towards the property. And since April up to May of this year, the total amount is 19,500. And I understand that plaintiff has a different view regarding whether there's a breach of contract and they're seeking specific performance. But needless to say, the plaintiff is still occupying my client's property, and they have totally failed to pay the rent, which is 1,500 per month since April of 22, giving us a total of $19,500. And with that respect, Your Honor, we're asking this court to order the plaintiff that if she continues using and operating my client's property, that she be responsible for, at minimum, the rental payments, and for the 19,500 that she's behind, that amount be either paid directly to my client or deposited in the registry of the court. And that's my first motion. I'm not sure if the judge wants to hear the second motion or give Mr. Saloma an opportunity to respond.
Yeah, let's stop right there. And what I was trying, I do see a response on the motion to compel, which if I'm not mistaken, has to do with her deposition.
Yes.
But was there a written response, Mr. Saloom, to the temporary motion for temporary injunction?
No, Your Honor, there was no written response to that. That's correct.
Okay. Just making sure. We're having a lot of Odyssey issues of things being filed and rejected, and so just wanted to make sure. Let me hear your response, please.
Yes, you're correct, Judge. Yes, not quickly, Judge. As Mr. Lopez alluded to, the parties entered into a lease with an option of purchase, known as an executory contract under Texas law. The term was from the January 2020 through January 2022. Thereafter, my client would have an option to purchase the property. It's a commercial property at an agreed upon price. From January 2020 to January 2022, my client timely made all rental payments due under the contract, under the executory contract, as I referred to. In March, in February and leading into March of 2020, my client obtained the proper financing through a private lender to purchase the property. However, there was a boundary title defect that would not allow the property or the transaction to close with proper title insurance. That was brought to the attention of the defendant's landlord owners, but it was never remedied. Instead of working towards a resolution to clear the title, they moved for a couple of FED actions, eviction actions, in attempts to evict my client. Those were dismissed, as Mr. Lopez did allude to, and this action was filed because there is in fact a commercial contract in place signed by both parties that lays out the terms of the agreement. And we at this point, we are seeking specific performance, or in the alternative, damages to the defendant landlord's breach of contract. Judge, at the inception of the lease, my client put down a $10,000 deposit. That deposit wasn't in the form of a security deposit. It was meant as a down payment to the property. As we know, since the pandemic, roughly around 2020, real estate has appreciated in value astronomically, Your Honor. We believe it's the defendant's position to just not sell the property at the agreed upon price, because they could probably fetch a lot more at this time. It's our position that my client, the plaintiff, has always maintained her contractual obligations. She has a right to seek the remedy of specific performance, and that's why I pled in the lawsuit. And we believe she has an interest, or at least at minimum a claim to title of the property. Now, Your Honor, if funds are ordered by this court, we don't believe it should be in the form of rental payments. We believe it should be in the form of a mortgage payment paid into the registry, to be held until a final trial on the merits can be heard, Your Honor. My client didn't stop paying rent out of nowhere. She just exercised her option to purchase the contract, to purchase the property, which was in the original agreement between the parties.
Anything else, Mr. Lopez?
Yes, Your Honor. Well, by their same presentation to the court, Your Honor, they're acknowledging that they're residing in the property, occupying the business as a business, the plaintiffs, yet no payments have been made, period. And if we go by the lease agreement, they're still responsible on a monthly basis to pay the rent until this matter is fully adjudicated. So the lease agreement still holds, and they're responsible for monthly payments of $1,500 a month. It is totally unfair that they claim that our client breached the contract, yet they continue to operate and occupy the premises and not make zero payments.
Mr. Saloom, go ahead. You're going to say something.
I just wanted to point out one thing. Our position that the lease, the executory contract, the lease agreement portion, it expired on its terms as of January 2022. I understand my client maintains possession of the property. However, we filed suit because we believe the defendants breached the contract. There's no attempt to alleviate responsibility to pay sums due, but she wanted to purchase the property. That's the whole point of seeking relief in this court.
Your Honor, may I respond?
Yes.
If they're seeking to enforce a contract and they're not paying rent, like counsel indicated, then they should move out. They should move out, and so that my client can continue using that property, subject to whether there was a breach of contract or not. But the fact that they're still there and essentially rent-free and not paying anything, that's the unfairness. And that's what we're asking this court to make an order, and not as mortgage payments, but just as payments, period, to the registry of the court for the $19,500, or to be turned over to my client. And for her to continue making the monthly payments if she's operating using the client's property, or she can vacate the premises and she can continue the fight while this case is going on.
Mr. Saloom, did I understand that in terms of, whatever the $1,500 represents for the period of time that she's occupied the property and not paid that amount, that I thought I heard the only distinction was maybe your position that it was some type of mortgage payment because the intent was to purchase, it's not a rental payment. Is that really for now the only distinction? That he's classifying them as a rental payment in the event the court were to order that those payments be placed in the registry of the court, that you all are not opposed to that?
Your Honor, I think so, Your Honor. However, the $1,500 amount was the agreed upon rent. I mean, I think the court needs to be aware that my client had the intent to purchase this building. She's made over $20,000 worth of improvements. If in fact she's not successful in her claim, that money is going to be gone. There's, at minimum, that amount should be offset. Now paying something into the registry of the court in the form of a mortgage, some type of security, is probably permissible, but to classify them as rental payments is essentially characterizing my client as a tenant, which I don't believe she is, Your Honor. I believe she has a claim to title of the property.
Your Honor, with respect to the improvements, the contract, the lease agreement states that if the tenant, the plaintiff in this case, wants to make improvements, she can certainly do so at her expense. So let's not mix apples and oranges here.
Well, is it silent as to, okay, if she makes improvements that will not be, taxed against any other type of payment she made? It's simply that if you choose to make improvements, you're gonna, basically eat the cost of doing that, and it's not counted against anything. Does the contract speak to that?
The contract just states that the tenant, if at their own expense, with written permission from the landlord, they can make improvements, but at their expense. So if they made improvements, obviously they have a business there, and they need to operate their business. So if they make improvements to fit their needs, that's fine, and they have to pay for it. But that's totally separate than my client not getting the rental payment, and has not received since a year now, a year and a month.
Anything else on the request for a temporary injunction?
No, Your Honor.
All right,
Nothing from the plaintiff, Your Honor.
all right. On the motion to compel, Mr. Lopez?
Yes, Your Honor. We've had difficulties in setting up the plaintiff's deposition. And obviously, because of the plaintiff, we wanted to take the plaintiff's deposition as soon as possible so that I can prepare for a motion for summary judgment. In this case, we tried to set up depositions, and you see it by our exhibits. We sent notices back in December trying to set up a deposition for the plaintiff, and we made some requests for January, 2 dates in January. We never got a response to that email regarding a possible deposition in January, specifically January 18 and January 27th. We sent another request when we didn't hear back in January 24th, again, asking for possible dates, that stating that January dates have come to pass, that we would like to depose the clients on February 15 or February 22nd. Again, we didn't hear anything, so sounds like we were being ignored. So we set up a deposition for March the 1st, and we notified counsel, and that's an exhibit also attached to the motion. We notified him on February 23rd that we set the deposition for March 1st at 2 p.m. And the only thing we heard was the day before saying that I think counsel or the party was out of town and will not attend the deposition. But the deposition had already been scheduled. We had to secure, Mr. Pacheco is limited in English, so we secured the services of an interpreter, and that cost $250. And obviously the no-show for the deposition was another $125. And just for the matter of the deposition, setting the notice, attending the deposition, preparing for my clients. I didn't know even at March 1st if they were going to actually show up or not. We showed up. So reasonable attorney's fees are at minimum $500. And that's very reasonable. But more importantly, we want to secure that Ms. Mary Gonzalez does not delay this any further by way of not being able to take her deposition. So we're asking that we issue an order compelling Ms. Gonzalez to a deposition and for sanctions for her non-appearance.
All right, Mr. Sullivan.
Judge, my client, Mary Gonzalez, has never evaded or has no intention to evade the taking of her deposition. I think a little history is appropriate. This lawsuit was filed on December 5th, 2022. On December 28th, the same month, a request was sent by Mr. Lopez via email inquiring about possible deposition dates of my client. Judge, I was out of the office. I did not see this email. Okay, it was sent on 12/28. Okay, as Mr. Lopez indicated, he sent a subsequent email to the incorrect email address, which I never received, on January 24th. Okay, Your Honor. On February 17th, Mr. Lopez noticed my client for a deposition from March 1st. It wasn't received by my office because it was sent by mail until February 20th. Okay. Now, the same day, I tried to contact Mr. Lopez because Ms. Gonzalez would not be available for March 1st. I placed phone calls to his office, and I sent an email to him which is attached to my response as Exhibit B. I attempted to confer and find available dates in March so that we could in fact set up a deposition. No response was ever had to this email. Phone calls remained unreturned. Thereafter, the next day, February 21st, a timely motion to quash the deposition was filed by myself because I hadn't gotten a response to, available dates, proposed dates from Mr. Lopez. Thereafter, on March 1st, the last day of February, I notified Mr. Lopez and the court reporter that Ms. Gonzalez would not be available for the deposition, but they chose to proceed for some reason. Thereafter, on March 1st, I sent a second follow-up email to Mr. Lopez stating I hadn't heard back from him. I called his office. I did speak to an assistant. No response had been had, and that Ms. Gonzalez would not be available for a deposition. Judge, the attachments to my response show that I was trying to conference and work out this minor discovery dispute out. I mean, the oral deposition of my client. And instead of conferring or trying to work things out, counsel just filed a motion to compel and a request for sanctions. Judge, I'm not exactly sure why that is. I'm not sure if Mr. Lopez has any issues with me, but the filing of this motion was unnecessary, Your Honor. It was timely noticed that Ms. Gonzalez would not be available March 1st. The evidence shows that I requested multiple dates, proposed dates, so that I could inform Ms. Gonzalez timely, and then we can get this thing going, Judge. So the initial request for a deposition was made before even initial disclosures had been done, Judge. So there is unfortunately a lack of communication. I'm willing to discuss dates right now, possible dates for May to resolve this issue. I'm not sure, why we needed, court intervention, Your Honor, and that's our position, Judge.
Mr. Lopez, anything else?
Yes, Your Honor. Well, the reason for that is because we've been trying, obviously, as you heard the other matter, she's not paying any rent. So there was an urgency from us to depose. She had already gone 8 months without any payment. And we're trying to depose her in December. We're trying to depose her in January, and we're just not getting any cooperation. So we set it for March, and that's how we got a reaction from the plaintiff. And he took an action, or he takes an action to motion to compel to be able to secure dates.
Your Honor, that's not completely accurate. Again, Ms. Gonzalez is not avoiding an oral deposition. She's prepared. We just need agreed upon dates, Your Honor. I'm not sure for the necessity to file a motion to compel when we're trying to conference. That's our position, and I believe that's what the evidence shows.
Yeah, the motion to compel is respectfully denied. With respect to the motion for temporary injunction, I had not printed out previously. I know there's some exhibits, including the lease agreement to defendant's motion. What I would like to do is reset or continue the hearing on the temporary injunction for 2 weeks. Mr. Lopez, if you can, in the interim, I don't know if it was circulated when you filed your motion, the proposed temporary injunction. I am not able to access it on Odyssey. So if you will email it to Mr. Hernandez, I don't know if Mr. Saloom has seen that, so I can review it. Mr. Saloom, because there was no written response, I heard your arguments today, but if you feel the need to file something in response to it, please do it. I'm going to say within, like by the middle of next week, so Mr. Lopez has ample opportunity to review it before we reconvene, okay?
Yes, ma'am. Yes, ma'am. Your Honor, may I clarify one thing?
Uh-huh.
Defendant's request for motion to compel and request for sanctions are both denied, correct, Your Honor?
That's correct. That's correct.
Thank you.
Mr. Saloom, if you have a proposed order on that, you can also email that to Mr. Hernandez.
Yes, ma'am.
Okay. All right. So we'll get you reset for 2 weeks. Okay.
Thank you, Your Honor.
On the temporary injunction. Thank you very much.
Thank you.
Thank you, Your Honor.
May I be excused?
Yes. Thank you. All right. Who's next?
Back on page 3, Judge. in cause number 2022 DCV 1577, Mountain View Baptist Church of El Paso versus Rafael Hernandez et al. Announcement of council, please.
Mr. Copeland? He was,
He got kicked out. Judge, going back to page 5, Judge, I've tried calling Ms. Garcia and send her an email with no contact at all, Judge.
okay. Let me get back to that case. Ms. Cables or Ms. Hernandez, can you tell me if she received notice of today's hearing? You know, if she opened it through Odyssey, I don't know if that's something we can see right now.
Which case is this for, Judge?
2022 DCV 0998.
Okay.
I think I'm gonna start printing everything with all the Odyssey issues.
Judge, I show everybody opened their notices for the hearing.
It's not listed.
Judge William Copeland.
Yes, Mr. Copeland, we'll come right back to you, okay?
Thank you, Judge.
All right, let me just pull up the, Mr. Dickey, it's your motion to dismiss, correct?
Yes, Judge.
Okay. And I think I saw here. Yes, Mr. Alfiero filed a response. All right. Mr. Dickey, you want to go ahead and proceed on your motion?
Yes, Judge. As the court can tell, we've defendants Francisco Arroyos and Ruth Arroyos filed a Rule 91A motion to dismiss the claims that are being made against it, which are, I believe, just negligent entrustment. The factual allegations in the petition state that, but there's no specific paragraph alleging that. But I think that's exactly what plaintiffs are alleging. Our position is that there is no basis in fact for the claims against Francisco and Ruth Arroyos. Just briefly, this accident apparently occurred at a parking lot of a Wendy's on Zaragoza. Mr. Isaac Arroyos, who is the son of Francisco and Ruth, was driving a vehicle and allegedly struck the plaintiff in the parking lot. There's allegations that Francisco and Ruth owned the vehicle and I believe negligently entrusted it to Isaac. There is no evidence that Francisco and Ruth owned the vehicle. In fact, plaintiffs admit in their response that there is no evidence that the vehicle operated by Isaac was owned by Francisco or Ruth. Based on that, I don't believe there's any basis in fact with regards to the claims for negligent entrustment against Francisco and Ruth. I do acknowledge that generally a factual allegation, if proven, would allow the court to continue with the case. But the whole purpose of Rule 91A is to prevent someone from just suing somebody else and then trying to find out or get the evidence later. There has to be some evidence of it before you file a claim against them. And normally that evidence that would exist prior to would be either a copy of the title, or maybe the officer listed them on the police report as the owner, even though that may not be accurate, but at least there's some evidence. There's no evidence here, and the plaintiff acknowledges that. So we believe this case is appropriate for dismissal under Rule 91A and ask the court to do so.
Okay, Mr. Alfiero?
Yes, Judge. I think it's too early. The standard is whether the pleadings, if true, would entitle them to relief. At this point, we don't know who owned the vehicle. I allege that they did. I don't have any proof that they did. I think it's too early. We're going to need some depositions. I think ultimately, if we can establish who owned the vehicle or the circumstances that Isaac was operating the vehicle, he's right, and I would have no problem dismissing them. But at this point, there's no police report. There's no info. The police report that was, or the license plate that was written down at the scene, I think is a paper tag that's not traced back to any owner. And it's just too early at this point. I think the standard of Rule 91 is met, that the allegations, if true, would entitle them to relief. And the other standard of whether any reasonable person would believe it, I think a reasonable person could believe that Isaac was operating his parents' vehicle.
But how are we tying them to the vehicle?
Well, we had substituted service on Isaac. There had been no answer. I had spoken to the mom, and she brought them in. I've got nothing tying them in except that there was a name exchanged at the scene. This is really a difficult case to try to get some facts without a police report, without any evidence from Isaac at this point. But I don't have anything tying them except that a background search didn't find Isaac owning any vehicles himself.
Holy smoke. So this was filed back in March of 2022, and we've never had anything in terms of a, let me see, in terms of our hearings. Mr. Dickey, I'm sorry, did you have anything else?
No, Your Honor. I understand what plaintiff's counsel is arguing. But our problem is I don't believe you can simply just, at least now, it's not the old law school idea is you sue everybody and then get the facts later. I don't think that's, I mean, I think our position is that's the intent of Rule 91A. You're supposed to have some facts to sue them. We represent Isaac. One of the issues, I mean, it makes it, the reason I think that this case could be dismissed is because the plaintiffs admit they have nothing. I mean, and really the only reason they're being sued is because they're his parents. And although it's not part of the motion, Judge, I have a copy of the policy that has been provided to me, and Francisco and Ruth do not have this vehicle listed on any vehicle that they've got or have their son listed on their policy. So it was a temp tag. My clients have no temp tag. It seems that they're just being sued because their son Isaac was allegedly driving a vehicle that struck somebody in a parking lot.
So let me see if Mr. Alfiero, this is my invitation to you to correct what I'm about to say. So in looking at your response, I think it says, if I can kind of dumb it down a little bit, defendants correctly note that plaintiff has no evidence that the vehicle operated by the defendant Isaac was owned by defendants Francisco and Ruth. So are you saying it's because you pled it, I'm supposed to rely on that to get past a motion to dismiss?
I think that's the standard, yes, and maybe I should have added plaintiff at this time has no evidence. I mean, they just filed an answer last month. We got initial disclosures, but I think depositions would really clear this up, and I think at least getting some evidence on the circumstances of what vehicle was involved, who owned it. I mean, it also could be that they own the vehicle. We're just going on Mr. Dickey's. I've got no reason to doubt him, but it's plausible that he was driving his parents' vehicle. We don't know what vehicle was involved. All I have is a license plate written down at the scene that comes back to no vehicle.
Okay. All right. Is there anything else?
Not
Oh,
at this time, Judge.
okay.
We do also have outside the motion, there's a status conference too, but the court may want to reset that since we're missing.
I do. I'm a little concerned why Miss Garcia is not here.
Judge, I spoke with her. I told her I have less of a claim against Cisco Homes than I do the parents. I said I was not going to move for default. She didn't have to do anything, and then she filed an answer out of the blue.
Well, that when you get a setting, you're supposed to show up. You all showed up. So I'm going to reset the status conference for 30 days. The motion to dismiss is granted. And so, Mr. Dickey, send me a proposed order on that.
Yes, Judge.
Thank you, Judge.
Carol, we'll see you in 30 days and we'll see what happens. Okay.
Thank you.
Thank you. Next.
At bottom of page 3, Judge. In cause number 2022 DCV 1577, Mountain View Baptist Church of El Paso versus Rafael Hernandez et al. Announcement of council, please.
Your Honor, William Copeland for Mountain View Baptist Church.
Okay, Mr. Copeland, we're set for a status conference. I believe this is our third status. How are we doing? Were we still waiting? Actually, I guess Judge Speasney reset you back in February. I felt like I was the last one to see you, but maybe Judge Speasney did. How are we doing on this one?
Judge, very good. I've got the affidavit from my process server that she's attempted to serve the defendant and the number of attempts she made. And she lists 3 different attempts. And she actually spoke to the defendant one time. And so now I'll be moving for substituted service, either at his place of business through one of his employees or through publication in a newspaper of countywide circulation.
Okay, this case has been outstanding, for a while. So I'm going to set you for, if you're going to file your motion for subservice, you need to do that ASAP. I'm going to set it for a status /DWAP in 2 weeks. If I receive your motion, obviously we'll get beyond that and I'll set you further down the line. But I'm showing, several statuses going back to May of 2022. So I want to get this moving, okay?
Yes, Your Honor. And that's reasonable. You've given me a sufficient time to comply with this. I think that I may have mentioned one time, just to refresh the court's memory, if you can remember 500 little facts. The fellow claimed, the defendant claimed he couldn't cross the bridge for about 2 years because we were limiting people from crossing the bridge because of COVID. But we will comply with what the judges said, and that'll take care of the problem.
Okay, just get your motion filed, please. And when you do, if you will also email Ms. Hernandez with your motion for subservice. So I know right now we're having a lot of issues with filing and Odyssey and whatnot. So a direct email to Ms. Hernandez will be helpful with your
Okay,
motion.
and that's one of your staff members?
Court coordinator, Ms. Myrna Hernandez.
Myrna Hernandez, okay.
Her
I'll
email
email
is,
her a copy. Thank you, Judge.
all righty. You're
May be
excused.
excused.
You are.
Thank
Hi, Mr. Rago and Mr. Spencer.
Hi, Judge. How are you? You're having too much fun today.
How are you? All
I'm
right.
good.
See ya.
In cause number 2022 DCV 0259, Alberto Villanueva et al. Versus Rodrigo Samonset et al. Announcement of council, please.
Good morning, Your Honor. Joe Spencer on behalf of the plaintiffs.
Derek Rago on behalf of the defense, Your Honor.
Okay, I think we were coming back here on the motion to compel. You all were going to work on some things if memory serves. How are we doing on this one?
Yeah, Judge, you on March 29th, we had the hearing and you ordered that Mr. Rago produce the discovery by April 11th. He did not produce it on April 11th. He produced it on April 12th, the morning of our hearing that we had just a few minutes before our hearing. We are set for depositions currently on May the 8th and May the 23rd, and then we're set for mediation on the 31st. If you recall, Judge, this was a case where I'd been asking for depositions since January. We are barely going to get to the depositions now because Mr. Rago had not made his clients available. Our expert designation has already blown by. Our discovery deadline will be done here in the next few days. So we really need, and that was one of the motions that I had filed, was a motion to extend expert designation as well as our discovery deadline, because given the lack of cooperation on behalf of the defendants, we have not been able to get this case ready.
Mr. Spencer, are we talking extending those deadlines vis-a-vis the August trial setting? So I guess my question is, do we want to keep the August trial setting?
I'd like to keep the August trial trading. I just need the deadlines extended, Judge, so that I can go ahead and and then maybe I would let you know, depending how the depositions go in the next week or so, I'll have a better idea.
Are you all able to come to an agreement in terms of that extension and maybe just file that by agreement, Mr. Rago or Mr. Spencer?
I think so, Judge. I would like to pipe in on the August date, Judge. As I stated to you before, these individuals also have the criminal case on the same matter pending. And I'd rather hear this after, and I've explained this to Joe. I think we can get more information because they're going to be basically taking the fifth on most of this stuff right now. When this case started, there was no criminal case pending. Ever since the criminal case started, we have a difficulty of doing anything that's going to jeopardize the criminal case. So, I mean, if you all want to proceed, I mean, it's going to end up being pretty much a default and then a bankruptcy. So, I'm trying to prevent that. We're working with the defense attorneys. I've already talked to the defense attorneys about this, and they want to get the judgment rendered in the criminal case so we can get it straightened out. But if anything happens with the civil case, where we have to protect the assets or anything of them, then it's going to cause problems on the criminal case.
For now, obviously there's no, I don't see a formal request to extend anything other than the discovery and expert deadlines. Without changing anything else, if you all can come to an agreement on those, we do have interim settings. If at the end of the day, Mr. Rago, what that means is, we're here on some other things, but I guess from your perspective, if you're asking in term for a continuance, just file it so we can have it heard. Looks like we have final status coming up quick, well, in a month, and then in July, and then we're at our docket call. So I would say definitely by the final civil pretrial.
And just so you know, Judge, the reason I haven't is we have mediation set at the end of the month. And if we get it resolved, then we wouldn't need it. So
right. So we'll wait. But in the interim, let's get those deadlines extended so we're not going back and forth on that. And that won't be an impediment. So please file that, I guess, as a Rule 11.
Yeah, sure.
Once you figure out those dates. Okay, we'll see you on June 7th.
Judge, you were also going to, I think, make a decision on with respect to the attorney's fees on the motion for sanction that we had filed, depending on whether or not Mr. Rago had complied timely. I mean, I guess my frustration is that, we've been asking for these deposition dates forever and ever. As it is, the disclosures were finally responded to by the defendants 5 months late. Everything has been late in this case, Judge, and it's just been painfully extracting information to get ready for trial. I hear Mr. Rago say that basically his clients are going to maybe take the fifth. Well, I mean, that's their choice. They can certainly do that if they'd like, but as the court knows, that can be used adversely against them in the civil case, and we can still proceed on the civil case. Then I hear Mr. Rago say, well, he's concerned about protecting assets. I'm concerned about getting justice for my clients that had close to $1 million stolen from them by the defendants. And Mr. Rago is interested in protecting the assets his client has stolen from my client.
In terms of the, go ahead.
May I respond, Your Honor?
You may.
We did file it the day late. We requested the day of our last hearing to my client. As I advised the court then, we produced all documents in their control. He had to request, both parties had to request documents from a bank that the accounts were closed on, which was GECU. We still have not gotten those documents. We did produce the documents we had from the bank. The other document that we did produce was the 2019 tax return that he had to request from the accountant. We got that the night of the 11th, I believe, and we produced it the next day. No other documents have been produced because we don't have any other documents, and that's what we explained in our production. So we can't produce what we don't have, Judge. There's been diligent efforts to get them. Mr. Spencer wants us to produce documents that are not in our control. And after diligent efforts, we got one, and we're still waiting on others. And they're just bank accounts from 2018. So, you know, when we get them, we'll get them to the court, but we can't do much more than request them. Mr. Spencer obviously has the ability to subpoena bank documents if he wants them. But we've requested them, and that's all I can tell Your Honor at this point.
There's no excuse for not having their own tax returns from 2018, 2019. It's just interestingly enough, the years where where the defendant stole from my client, those tax returns are conveniently not being able. The defendants are telling you they don't have control over their own tax returns. I mean, I just find that hard to believe. And then why is it taking months and months and months? Are you requesting at the last minute when we asked that from the very beginning?
That's incorrect, Judge. We produced 18 and 20. We were missing 2019. He had to request from the accountant, and that's who sent it to us.
Mr. Spencer, in terms of a decision on the relief, in terms of the attorney's fees, and I didn't recall seeing sanctions. I may have overlooked that.
Yes, ma'am.
I will rule on that when we return on the June 7th date after you all have attempted your mediation.
Yes, ma'am. Okay,
All right.
Judge.
Thank you, Your Honor.
Anything else?
Excuse, Your Honor? No, Your Honor.
You may. Thank you both.
Maybe excuse, Your Honor.
You may.
Thank you.
I see Miss Nolan. She's been waiting a while.
Yes, I'm here, Judge. Good afternoon.
Good afternoon. Good afternoon. Good morning. Okay.
Good morning. I don't know.
In cause number 2021 DCV 4254, Marta Carrillo et al. Versus Integrated Life Improvement Services et al. Announcement of council, please.
Miss Nolan, are you there?
I'm here. I'm sorry.
May have
I
your
was
number?
looking, I'm in Houston. I'm sorry, it's the afternoon here, but I'm here, Kaylin Nolan, representing Martha Carrillo and Jerome Overstreet, the plaintiffs in this case.
Okay. Do we have, it looks like it's Mr. Brown had filed the motion to withdraw. Is that right?
I didn't file the motion.
I know. I know it says Adam Cetra, but Troy Brown is listed on the motion to withdraw. I believe he covered. Do we have Mr. Brown?
No, Judge. I did not have him on Odyssey. I didn't see his name.
Yeah, Mr. Cetra is, I believe Mr. Brown has taken over. Let me see. Look at this motion to withdraw. So there was a motion to withdraw as counsel and substitute new counsel filed on January 23rd with the notification that Mr. Troy Brown would be subbing in now for Mr. Cetra. So that needs to be updated. Of course, now he has filed a motion to withdraw. So Ms. Nolan, it doesn't appear that the court notified Mr. Brown for today's hearing. I will ask you because you have appeared, and my intention then is to probably set this for 30-day status and just rule on the motion to withdraw based on the submission. If you had any type of position or anything on that.
I have no objection to the substitution, and I've been staying on the case. I've told them that, you know, I don't have the availability to continue. So I've been giving them time to seek other counsel, and they're supposed to have been doing that. but it's been a long time and they still haven't secured another attorney. So
Miss
in the
Nolan,
30,
Miss Nolan, when you're saying they, you mean your clients?
my clients,
Uh-huh.
yes.
Okay.
And so I'm going to also be, just to let the court know, I'm going to be filing a motion to withdraw myself because they haven't been able to secure the other counsel.
Okay, if you will do that quickly, I'm gonna set this for motions to withdraw and DWAP in 2 weeks.
Sounds great. And I'll get it within the next couple of days for sure.
Okay, if you have a proposed order, go ahead and do that.
Okay, that'll be great. Thank you, Judge.
Thank you for your patience.
Mhm. Bye.
Ms. Cable's